morning, my name is Jacob Zoglin and I'm here to talk to you today about area variances. So an area variance is what is required when you want to build something that is either larger than is permitted by municipal setbacks, or perhaps that would have a greater area coverage than would be allowed under the zoning code. In those cases, when you can't get a simple administrative adjustment, often what's required is an application for what's called an area variance. Usually the way that happens is the applicant applies to the Zoning Board of Appeals for this area variance to allow them to exceed, for example, setback requirements or lot coverage requirements. And so when that happens, the zoning board's responsibility is to make the determination about whether the benefit sought by the applicant, if the variance is granted, outweighs the detriment to the health, safety, and welfare of the neighborhood or community that the variance would cause. And so in making that determination, the zoning board by law has to balance 5 factors. And so the first factor is whether the variance, if granted, would cause an undesirable change in the character of the neighborhood or a detriment to nearby properties that would result from the granting of the variance. The second issue that the zoning board has to consider is whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. The third factor that gets considered is whether the requested variance is substantial. And there are a lot of different factors that can be considered or that can go into a determination that a variance is substantial. The fourth factor that's considered is whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district in which the area variance is sought. And the fifth factor that's considered is whether the alleged difficulty that the area variance seeks relief from was self-created. And although that consideration is relevant, it is not alone something that would preclude the granting of a variance. So those 5 factors get considered in making the final determination about whether the benefit to the applicant, if the variance is granted, outweighs the detriment to the health, safety, and welfare of the neighborhood or community caused by the grant of the variance. And finally, in making the determination to grant a variance, the zoning board is required to only grant the minimum variance necessary and adequate, while at the same time preserving the character and neighborhood, character of the neighborhood, as well as the health, safety, and welfare of the community. So it's a balancing act, both in terms of weighing whether to grant the variance in the first instance and in determining what the minimum variance necessary is to achieve the benefits sought. So whether you are seeking a variance to allow you to exceed certain requirements under the local zoning code, or whether you are a nearby property owner or business owner, community member who wants to oppose a variance because you think it'll disrupt your community, either way, whether you support it or oppose it, you need to come to the zoning board prepared to present evidence on each of the 5 factors and convince the board that these elements weigh in your favor. To do that, it's important to have an attorney that understands the law and how the facts affect them. So if you have questions about area variances, give us a call at the Zoglin Group and we'd be happy to help. Have a good day.